guys, it's Kathy. How are ya? How you doing? I really, I really hate this mute button lately. For some reason, I can't figure it out. Wishing everyone a Merry Christmas. Jim, you're not gonna be in here before Christmas? Come on, come on. Where's Kelly? Where is she? Somebody tell me where Kelly is. I can't stand it anymore. I'm gonna drive to Texas in a second. Just drive around shouting, Kelly, Kelly, Kelly. Who's feeding Chekhov? All right. So, you, you might think that I started muted on purpose today because of what I'm about to show you that Fozzie gave me, but I didn't. I just don't learn my lesson. This is what Fozzie gave me today, guys. You ready? So I'm going to start a new stream real quick with sound. I'm going to have the right. Look, we're going to look at this together. This is where we're at. We're at 10. We're going to start 10. We're going to be fine. And I'm not even going to do an intro or outro. I'm just going to start the stream in like 1 minute to get it set up and then start OJ. Thank you so much for coming out, guys. I really
3 minutes later in the very next video.
remember I said we were going to have sound for this? I lied. I lie all the time. Hi, guys. It's Kathy. I hope you're doing well.
Love you, Kathy. Bye.
My Lord. Do you see how people told me I was muted while I was playing a video of me being muted? The whole point was that I was muted, but thank you for telling me I was muted. Darkest Night is here. He's always so busy. Darkest, thank you so much. You're gonna make 50 people happy for Christmas. Listen, I can rewear a shirt. It's not like I'm doing anything here. I'm just sitting here. 100. 100. Darkest, thank you. Thank you so much. That is huge. Listen, come in here more. You don't have to buy memberships. Just come in here more and forget about all that garbage. Just forget about it. You can come in here. You can listen to me and Bergentile fight. Hi, Bergentile. Darkest, we love you. Look at this hottie right here giving you a green heart. Yeah. Okay, so where do I begin? There's too much to choose from to begin today. Um, we haven't seen this one in a while.
Claim, Your Honour, is in paragraph 12 of the statement of claim, which I'll just seek to summarise. The effect of the claim is that
I hit the
Dr.
wrong button
Kolodziejczyk
again.
began research and development into what's known as ionic liquid,
Ionic liquid.
R&D,
Okay, Fozzie. Okay, we're gonna start with
for the reduction of iron ore
heartwarming.
down to iron
And the record to reflect the defendants have failed to appear. Good morning.
We're going to start with something a little heartwarming before we move into the crazy, crazy.
Ms. Allers. Good morning. And you may proceed and call your first witness.
Call Leslie Barth.
And Ms. Barth, if you'd step up to the witness box, raise your right hand to be sworn in, and you can take the records with you. Just if you need anything. Raise your right hand. Do you swear or affirm that the testimony you are about to give in the matter presently before this court to be the truth, the whole truth, and nothing but the truth, and this with the penalties of perjury? Yes, ma'am. Thank you. You may inquire.
Leslie, what is your position with Gerald DePalmo, trustee?
I am his office manager and his daughter.
Both? Okay.
Her dad needs.
Okay. And are you personally familiar with the tenancy at 222 and a half Mount Vernon Road?
I am. I have known them for many, many, many years. I've rented to them 3 different times.
Okay. So you actually know Ms. McCollum and Mr. Williams personally also?
Yes.
Okay. And you're here today Representative DePalmo, the trustee, who is the owner of 222 and a half Mount Vernon Road. Are you personally familiar with the lease
I have a
between
copy.
Mr. DePalmo and the defendants?
Yes, I signed it.
Oh, okay. And I'm going to show you Exhibit A we attached to the complaint and ask you if you recognize this.
Yes, ma'am.
Is this an accurate copy of the lease?
It is.
And did the defendants fall behind in rent?
They did.
Is Exhibit B an accurate copy of the 3-day notice to leave the premises?
It is.
And how was this posted, or how was this served, on the defendants?
By taping it to their door.
Okay. Have you accepted any payments since this was posted?
I have not. They haven't been any.
Are they still on the property?
They are. It's the criminal.
Okay. Nothing further, Your Honor. That's you.
I know.
Oh, I was like...
You'll excuse me, I'll turn it off. I didn't realize it was still on. Bummer.
And based upon the sworn testimony and the exhibits attached to the complaint, which will be admitted for purposes of this hearing, the court finds that the plaintiff has established a right to recover possession of the premises, will recommend restitution. The premises will be posted with a court-ordered vacate date, December 16th at 4 p.m., and then the premises will be posted by our bailiff with a court order on Friday. Are you familiar with any circumstances at this property that could be dangerous?
No. Can I ask you something off the record?
No, ma'am. No, it doesn't work that way. So anything off the record, you need to ask your attorney. So if you need to ask your attorney a question quickly, and if you can hit the button to mute the mic.
Can we push it up? You rolling through them? She's done.
My client would like to voluntarily ask that the vacate date be after Christmas.
All right. So let's check here. Of course, under Ohio law, you're entitled to have this tenant set out within 10 days.
Just don't go down.
So that would make vacate date Monday, December 30th at 4 p.m.
That's okay on the vacate date. You just have to do the set out the next week.
Okay. Very good.
Just ignore that.
So now we're at 12:30 at 4 p.m. Correct?
So the after Christmas, they're evicting this woman or man or couple or family, I don't know. But they're like, nah, let's just wait till after Christmas. I saw a lot of landlord tenant today, and none of them waited till after Christmas, except for her. Okay. The sound is going to be okay on this, guys, because I did everything I was supposed to do. I moved everything from the left to the right. I balanced it out. I reduced the noise. Nobody's going to say, except for people who are trolling me, I can't hear. I can't hear. I know it. This is going to be right.
Great, Mr. Kirk. It looks like you're here for a release hearing, and the state looks like has filed a formal charge charging you with the same offenses you were arrested for, battery and breach of the peace. You already have the public defender. You already have a court date. Yeah. December 19th, in front of Judge Baker for DACA sounding next week.
Yeah, Judge, can I say something?
Sure.
First off, I wanted to get a message to the state attorney's office, the judges, and anybody that works in the courthouse or the sheriff's department. I used to own a computer company. I reported some drug dealers in Clear Lake area at the Taco Bell and Long John Silver's. Long John Silver's backed out, and then I witnessed personally people hacking cell phones in mobile phone stores in the Clear Lake area and outside of mobile phone stores with drug dealers. My advice, I used to own a computer company for security concerns, is not to have Google Maps and Facebook on personal phones that travel from home addresses to the courthouse or from home addresses to sheriff's departments. And anyways, I walked into a restaurant and said, I'm in fear for my life. They're trying to murder me. And then I ran down the street. What are you doing?
All right, Mr. Lopper, did you get all that?
I got it, John. Thank you.
All right, thanks. All right, let's see, the next one is Jasheen Riggin. Oh, hold on one second. They're still working with Mr. Kirk. I haven't seen Mr. Kirk in a while.
Captain Kirk.
Yes, Judge, and I marked him off to make sure that the his attorney knows that he's got some serious competency issues. Try to head it off.
I wish this sound was better because this courtroom every day provides this every day, multiple times a day. But the sound is so terrible. Maybe. Okay. We're going to go to... Okay, if a judge ever said these words to me, I would never vape ever again in my entire life.
Yes. Yeah, okay. Mario, raise your right hand. Mario, do you affirm you will justly, truly, and impartially interpret to the court any parties and witnesses in the oath that about to be administered, or any questions may be asked and answered?
That's funny, Critter, because I was going to play a full hour of that court, but the sound is just so bad that I don't know if I can. But I was just going to let a whole hour play because it was just, it was just that after that after that. Anyway, she's a high schooler, and that's her mother. And this is Judge Riggins.
May be given as court when a cause may be considered during this court session.
I do see, Ron.
All right. Court will take judicial notice of the Townsend Mario Hayes, who has been a court interpreter for over 20 years, who speaks many languages, including Spanish and English fluently. All right. Tell me your name. Raise your right hand for me, Ashley. Do you affirm under pain and penalties of perjury, testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Listen, that's perfect. If they don't love you for that, then they're not worth your time.
Yes? Okay. Ashley, you're very soft-spoken. You have to speak up because we record it, okay? Plus, Mario needs to hear it so he can interpret for your mother, okay? All right. Tell me your full name. Date of birth. All right. August 10, 2008, right? Okay. You are charged with possessing an e-cigarette or tobacco. It's an infraction. There's no jail time, but I can fine you up to $500 if I find you did do it. State would have to prove you did it at a trial. In that trial, they have to prove it by a preponderance of the evidence. It's not beyond a reasonable doubt because it's not a criminal case. Your choices today are admit or deny. If you admit, it'll only be $160 and I'll give you some time to pay. If you deny, I'll set it for a trial. Do you wish to admit or deny? All right. Did you talk about this with your mother? Yeah. All right. Okay. All right. And after talking about it, you wish to admit, is that correct? All right. What did you possess? A vape? Where did you have it? At school? Where do you go to school? Are you a sophomore or junior? How are your grades? Why okay? Why not excellent? Struggling because you've not put the effort in, or struggling because you just have difficulty comprehending it? And the second one, what are you struggling in? Well, Math and I didn't always get along real well.
The judge is repeating everything back. She's just really soft spoken. You can hear some words if you try, but it's okay. Don't worry. It's what the judge is about to say to her that does it.
But there's a lot of services out there, even on the internet. There's a lot of things that explain how you do. What are you taking now? Are you in algebra or calculus or pre-cal? Okay. All right. Why did you bring this to school? When did you start vaping? The week you got caught? You maybe think that might be the universe telling you maybe you shouldn't vape because you got caught with it. What was in the vape? Was it, No? I'm not asking for a name, but where did you get the vape? From a friend, from a store, from a friend? Was it in its original packaging? No.
Okay, guys. If you ever were gonna smuggle vapes, if you go to prison or if you are back in school someday, never ever accept a vape from someone, because this is why. Hi, Lisi. Are you ready?
So, did you get it at school from the friend? Yeah. That friend, where are they today? School, right? Where are you? Right? Where would you rather be? Right? So, this thing you put in your body, you don't know what it is, don't know where it's been. If your friend snuck it into school, was your friend a female or a male? Female. So, my experience has been, if girls think they might get searched, where are they going to put it? In their bra, right? So that's just like putting, dirty, sweaty, nasty high school girl bra, then you're putting that in your mouth because you're not sterilizing it, are you? No. Guy, he'll put it in his pants. You wouldn't pick a cigarette off the floor and smoke it, would you? That's the same thing you're doing with that.
Got it, Judge. Never gonna touch a vape ever, ever, ever again in my whole life. Ever.
Right? We don't know what's in it. We don't know who made it. The stuff, the juices and the THC, those are made in some clandestine lab somewhere. There's some dude stirring a pot of that junk. You think he cares if he gets a mouse turd in it? No. It's anything like that. He just keeps stirring it. He'll just laugh thinking about that stupid American that's going to be smoking a mouse turd. These aren't regulated. That juice and stuff is because it's illegal. And yet you're putting it down deep in your body, right? Have you had biology yet? Okay, so you're going to learn about how we exchange oxygen. We have the oxygen molecules that we breathe in, and we have the carbon dioxide that we breathe off, and how those exchange at the alveoli area, and then it's one cell thick that it exchanges. You're inhaling the stuff deep down into that area. We don't know what it's going to do, right? We have no clue. You guys are like lab rats because we don't know what the stuff's going to do, right? Look, I'm sure you're a good kid, Ashley. This is not the end of the world. And I got kids your age, okay? I'm not mad at you, but what I want you to do is learn from this experience, okay? And I want you to think about what you're putting in your body, because the people that make these things, you know what they're out for? Money, dinero. That's all they want. They don't care about you. They don't care about your health. They don't care about your family. They don't care about you're in trouble. They want to market a product to you so that you use it and it makes them money. That's the only concern they have, and by participating in this, you're allowing them to do that. What do you want to do when you graduate? That's okay. Well, what interests you? What do you think you would like to do?
She might She might after the boob sweat and the whatever.
Be a lawyer? Okay, well, awesome. Well, good. Well, we need good lawyers, and this is not going to stop you from being a lawyer. Okay. I did dumb stuff too. But the question is, do you learn from it, right? And law schools can be difficult. Not a lot of math, thankfully, but you still have to do well. Okay. So your friend that gave this to you, do you know what they want to do when they graduate? Okay. Well, you have high aspirational goals, and that's good. And life will put enough barriers between you and your goal. By continuing to disobey rules and acting like this, that puts more barriers between you and your goal, right? So we want to eliminate the barriers between us and our goals, right? And so if you want to be a lawyer, if you want to be a professional, doctor, lawyer, whatever, then you've got to act and conduct yourself differently than somebody who's satisfied to go work at Walmart, right? And so if those are your goals, you have to act differently. There's some old sayings, if you want to soar with the eagles, you can't be up with the owls all night, So that's kind of what you take. I hope you take to heart from this. Okay. Are you supposed to be in school today? Okay. So I'm going to give you 60 days to pay. Okay. So that's plenty of time. Do you work? What do you do? Okay. Which one? Out east or North 9 or what? North 9? Okay. All right.
Now the real punishment comes. Here it comes.
Well, pay your mom back or pay it yourself, whatever you got to do to take care of this, okay? And that's plenty of time to do it. Now, this is not a field trip today. Don't be asking your mom to go to McDonald's or anything.
Rude. She doesn't even get a mom, I just got out of court meal from McDonald's. All kids get a mom, I just got out of court meal from McDonald's before going back to school.
Get your butt back to school today.
This is not juvie court. No.
Okay. All right. Any questions? Okay. All right, Ashley. Do better because I know you can. Okay. All right. So you just, when you pay, you come back to the clerk's office and pay in the clerk's office. Okay. Any questions? All right. You're free to go. Thank you, Mom.
No boob sweat nuggies for her. Oh. Okay. I'm just going to play it.
I have a personal interest against Mr. Hansen. He used the word vendetta. I don't have to make that fit the facts. That was what he came in here and said.
Okay. That's the prosecutor talking. The prosecutor is saying that this guy right here said that she has a personal vendetta against this defendant. Okay? It may be true. It may not be true. We don't know. But now he's going to defend himself, and then everything's going to fall apart. Hi, Rose.
That is offensive to me and playing games with the court.
And actually, Judge, that was my client's word to me. That was not my word. That was my client's word. And I was quoting that from an email that Ms. Archibald sent me earlier this week. I am not asking that Ms. Butler be taking off this case. I'm being very clear on that right now. And I was very clear on that previously when I said that I am not asking for her recusal in this case. I am asking that I be taken off. And I think this exchange right here in this courtroom, I think is enough to show that this court, that I am not necessarily the appropriate person to be representing Ms. Archibald moving forward, particularly if there is going to be a trial setting coming back up, possibly. I don't know what is going to happen. If Archibald used the word vendetta, that I don't know that I'm going to disagree with that word, very honestly. But to that end, I do not believe that I am the appropriate person to be representing Ms. Archibald moving forward on this case. And I think this exchange in this courtroom today is enough evidence to show that enough.
All right. Well, this is a little disheartening for several reasons.
Hey, Terry.
One, there's no conflict under burglary. There's not a conflict between Mr. Hansen and Ms. Archibald. So that's kind of an interesting dilemma. Excuse me, because the case law in this scenario all relates to a determination of whether there is a conflict or breakdown of communication between the client and the attorney. And so if you go do a search for cases related to something like this, what you find is the burglary factors. And if there's not a conflict, then the ADC's doesn't withdraw. I understand that's not what's going on here. That's not the argument being made by Mr. Hansen. You know, I can sort of think back to a person. It's anecdotal, but it's a personal experience where I had
No, not exactly. It's confusing, but she does not get along with the prosecutor. She does not get along with the prosecutor, so she wants him gone.
trial early on, where, you know, I had a lot of distrust for the attorney. And then, you know, by the time I left, that was one of the attorneys I trusted the most. So, you know, things ebb and flow. And, you know, it's one of those situations where if the DA and the public defender or the district attorney and the private counsel, you know, aren't getting along or don't, you know, like each other, then, I mean, that's a lot of cases, right? That's a high number of cases. So, you know, what do I do in this scenario? Not a lot of great guidance. It's kind of problematic because I'm inclined to say no, but I think it would be easier to say yes. So that I don't hide stuff. That's me just showing you my hand. I mean, it's hard for me to look at this and say, I mean, Mr. Hansen, are you off my ADC list? Yeah.
I'm not off your ADC list, Judge. I will tell you that I have voluntarily not taken cases with Ms. Butler assigned as a prosecutor for multiple months at this point. I will also indicate that an ethics attorney has reached out to me about this particular situation because there are other situations that Ms. Butler is under active investigation for through OARC. I'm not raising that in this courtroom for any other purpose other than this came to me.
All right. Here's what I'm going to do. Ms. Archbell, let me have you come to that podium real quick. Actually, you can stay seated. There's a microphone right in front of you. Just make sure you're talking to that microphone.
Yes,
I am
sir.
not going to talk to you about anything about your case. I do not want to talk to you about the facts of your case. I don't want to talk to you about the allegations. And I do not want to talk to you about private communications between you and your attorney.
Yes, sir.
That is not what I want to talk about. Based on what you've heard today, if I was, and I'm not going to do this, but if I was to set your case for trial today, right now, and Mr. Hansen was your attorney going forward, how would that make you feel about your ability to get a fair trial?
It would make me feel like it's, I feel like there's been a lot of accusatory and unjust comments and multiple things coming from the DA towards this case. And you said that you don't want to talk about that. I can give specifics about the way that I feel.
Yeah, I don't want to get into
But I
specifics.
I feel
I want to keep this very general.
Talking to from my opinion with my conversations, I feel like it would be completely unjust because of problems that have occurred during this case, comments that have been made. I don't feel comfortable in a courtroom with the DA at all.
Right. Well, but the DA doesn't change under this scenario, right? So
I'm aware. I was given the advice that it is easier to possibly get a different defense than get the DA off.
That's an accurate statement because the way the standard.
If I can't get a different defense, then I most certainly will proceed with filing the motions to get her removed off of my case.
Okay. So you understand that if I do allow Mr. Hansen off your case and I appoint another alternate defense counsel, like I don't even know who that would be right now. I mean,
I understand
it could be literally anyone on the ADC list. You understand that?
I would like to put out there to not allow Mr. Lemus back on either of our cases as he's already been taken off.
That wouldn't be, it wouldn't be Mr. Lemus.
Otherwise, I'm fully aware that it would take time.
So it sounds like this is number 3, public defender.
We'd have to find it. I'd have to come back in for another appointment of counsel, and that they would need a certain amount of time to be able to get familiar with the case, and then we'd basically start all over. Yes, sir, I'm aware.
And you understand that you don't get to pick them. I don't get to pick them. It really is sort of who's on the list and who has availability, right?
Yes, sir.
So understanding that it's almost like throwing a dart at a dartboard and whoever it hits is who your lawyer is. That makes you feel more comfortable than proceeding right now with Mr. Hansen? I stated that as a statement. Does that make you more comfortable than moving forward right now with Mr. Hansen?
With comments and things that have been made during this case, yes, sir, it does.
Okay.
Obviously, the prosecutor. She has a vendetta.
It's an interesting issue because I do actually think that sort of creates a conflict between you and Mr. Hansen.
Yes, sir, it does.
Not in the classical burgerage sense. We did not.
What was that other one? What was that other one? Shanana with Bowser? Is it Shanana?
Just have a burgerage hearing. I don't think that's a conflict in that way, but it is sort of this weird.
It's a weird ground to cover, yes, sir.
Yeah, it's a strange issue. It's a strange situation, and I think it does create a conflict, but not in the classical way it creates a conflict.
I agree.
So I am in an abundance of caution. I'm going to allow you to withdraw, Mr. Hansen. I'm very disappointed right now.
I don't like it.
I'm not casting blame at anybody. I'm not taking sides. I'm not saying either of you are wrong.
Fozzie excelled at potty training. It was one of his favorite activities to get to that toilet.
I'm just saying I'm very disappointed. So what I'll do is I'll allow you to withdraw. Mr. Archbell is in the courtroom. Your attorney is not here. What I'm going to do is I'm going to ask Mr. Hansen, you will not be on this case after you walk out of the courtroom, but I am going to ask you to give a call to Mr. Krenning to explain what has happened.
He's aware.
Explain that I let you off. Because that might affect what he wants to do.
We actually saw him this morning and spoke with him, and he asked us to get in contact with him and let him know. He also knows that if it was approved by you, that he will be reaching out to whatever counsel is appointed to me. And
all right, come back on Thursday the 19th at 8:30. I got to get you a new attorney.
Yes, sir. I'll make it happen.
Does that work?
I have therapy for the first time at 10. But I will make it work.
Where's therapy?
It's in Loveland. It's only a 30-minute drive, so I'll make it work. It's okay.
You have it at 9:30?
At 10.
Oh, at 10? I'll call your case first on Thursday.
Okay.
All right. I'll see you then.
Thank you, Judge.
Thank you, sir.
And he probably said, Mommy, we need a shelf. Mommy, we need a shelf in this body. All right, guys. Here we go. It's time.
Miss Felvey, I'm not going to order Mr. Dawson-Erdman to act in a certain way.
I know.
Okay?
Yes.
Okay, so I can't order.
What she asked for, I was trying to get there. What she asked for was she wanted her what is it called? Relief counsel, that's not it. Standby counsel to sit behind the bar. She wanted him to sit in the gallery. And the judge said no.
A symbiotic relationship.
But he's my advisor counsel and his name's on the proceedings. So I think he's going to want to uphold his name and his dignity as an attorney.
Well, I
think he'll be fine. I just really, we've been at tug of war.
And you can disagree with the attorneys. I mean, it's okay to disagree with your attorney. I just can't, can't do is I can't order an attorney to see it the way you want him
I just
to.
want to get my witness and I want to see the dash cam and I want to be prepared for trial. And there's a reason because I feel frustrated that you appointed the attorneys that didn't work for me. And I feel like it symbiotically goes back to you accidentally on my part. So then I feel that this witness has a lot of things to say about her credibility.
Okay.
And
So here's
I
what-
don't think she'll do it on the stand with a jury.
So here's what I'm going to do. I'm going to turn to the district attorney and ask them for the following questions.
Right.
One, where's the body worn camera? Okay. Because you,
Yeah,
asked
we
for-
have that. The dash cam.
you said you have it.
We have the body cam, but not the dash
Okay.
cam.
I'm going to ask for the dash cam. Two, I'm going to ask their position on a motion to continue with a speedy trial waiver.
Okay.
And then three, and that doesn't mean I want to put it off for a very long time. It'd be 6 months from today, but we'd still have to reschedule it.
Okay.
And then three, restoring your right to a jury trial.
Thank you.
Okay. And then do you have any other motions or requests that you wanted to make at this time? Because I want to give the DA a chance to
What's
talk.
on there? Hold on. Yeah. Oh, yes, my witness, besides Miss Rain, my witness is Alexandra Elliott, and I think she goes to Switzerland this time of year. And I think maybe she'll be back. And
Alexandra Elliott.
Elliott, yes.
Okay. And then I think, and I appreciate your disclosure right now because you are complying with the rules, but let me just make sure. There might be one piece of information besides her name that you need to provide.
Thank you for accepting my motion late.
Yeah, and let's just make sure. I'm looking, Miss Felvey, at Rule 16 of the Colorado Rules of Criminal Procedure,
Right.
Part 2.
I think she's checking her phone for the address, Judge.
Okay. And yeah, so it's names and addresses that you'll need to provide to the
Okay.
DA.
Let's see. Okay. I had some tech trauma. My other phone screen cracked and my Chromebook screen cracked
Okay.
about a week, and I had to get to the doctor because I've been sick and I ran around and got this done, but I apologize for turning it in late, and I thank you for accepting that, and I thank you for hearing me and hearing me out and listening to me and getting this done, and so that I will feel better and it will be over and I will feel
Okay.
like
I don't know what's going to happen as far as the outcome of this case.
Nobody
but
does.
but I also want to say that it is important to me that you feel like you're getting your full day in court. So and I'm sorry that you don't have faith in the court and that your confidence has been damaged, but that's why that's one of the things we're addressing here.
Yeah,
So-
and I stepped forward to get on an even keel about all of that because it's been really frustrating for me, this whole thing.
Okay, so have you pulled up the address?
Yeah, sorry.
It's okay.
Let's see. I will get it to you if I can't find it immediately. She's on my other phone.
Okay.
And then my phone started working and my Chromebook started
So,
working.
Ms. Felvey, while you are looking at that,
Yes, sir.
the other thing, I'm now looking at the motion, and I know it's a late filed motion, but you're asking for a copy of Ms. Rain's driver's license.
It's exculpatory identity.
Well, okay, but I need to give the district attorney a chance to respond to that
Yes,
request.
Yes.
So,
Your Honor, I think
yeah, Mr. Dawson-Erdman.
I think that may be mooted. Like a DMV copy of Miss, the alleged victim's driver's license was recently disclosed through the discovery process.
Oh, okay.
Miss Felvey has a copy of it.
Oh, so that's
As if that, there may be some reason why that copy is insufficient from Miss Felvey's perspective, but
okay.
I have that now.
So then, Ms. Richardson, I'm going to give
Yes,
you. I'm
sir.
going to ask you the following the following. One, is there dash cam video for the 3 officers?
Can I respond to that portion in writing?
Yes.
Okay.
Okay. 2, with a waiver of speedy trial, do you object to a motion to continue?
I do, Your Honor.
Okay.
For a couple reasons, if I could elaborate.
Yeah, of course.
Ms. Felvey has indicated that there's now this witness that she wants to call, and she didn't know she needed the witness, yet she claims the witness was present there on the date of offense, which sounds like a pretty necessary witness if they were to call. So I guess the claim today that she's unprepared to have that witness testify seems unreasonable to me. And so I'd be objecting to a continuance.
She said she doesn't have the witness because they're not in town.
Well, it sounded like she didn't know she needed the witness until now.
Because I was told I didn't.
It's just.
And so then her efforts not to acquire said witness until right now seems unreasonable for her to think she didn't need that witness if they were supposedly there on the date of the offense.
Right.
So
You're saying Miss Felvey should have known prior to today that the witness issue was going to be an issue.
correct.
Okay. So that's okay. I hear that.
To today.
Okay.
And there was also a comment made that her witness wouldn't be able to take the stand in front of a jury. And I'm confused by that statement because she's now asking for a jury trial.
I don't think that's what she said. My understanding, Miss Felvey, please correct me if I misinterpreted. She believed that Miss Rain, the named victim, would be less inclined to be dishonest in front of a jury than in front of me.
Okay.
I think that's what, isn't that what you said?
Yes, absolutely.
Okay, so my impression was she was talking about the named victim that would be in her argument more held to the truth in front of 6 strangers.
Understood. But yes, the people would ask that the court keep the jury trial or the trial set. And then with regards to restoring the right to a jury trial, I would also like to respond to that in writing if possible.
Okay. So and if I granted the motion to continue with a waiver of speedy trial, is there any prejudice to the people for adding it back to a jury trial, or is that what you want to look at?
I want to look at that, Your Honor.
Okay. Okay. Is it true that you've now disclosed the named victim's driver's license?
The criminal history, Your Honor, that has the driver's license DMV information on it, yes.
Miss Felvey, in light of that, is there anything else you're trying to get?
Yes, it's on the body worn camera. She handed him a California driver's license and he listed it. I have the police report. He listed it as.
And you're looking for a Xerox copy of it or something? I guess.
No, I'm looking for the exculpatory identity of this woman because her credibility is not very good.
But I guess I'm a little confused. What identity do you think is exculpatory? I guess. Like, you think she's not who she says she is?
She has a lot of who she says she is. She has a lot of aliases.
Okay. And so
from the DA's own discovery, she has 4 now.
I understand that, but I guess this is what I'm just trying to find out. What is it? What's the offer of proof that you think a copy of her driver's license would show you?
Well, it shows that the police showed bias and coercion. They know Officer Mendelson never called in her driver's license, even though in the dispatch.
Well, you can ask him about that.
Oh yeah, I'm going to ask him.
Yeah, you can ask him about that, but I'm just I don't understand why you need the driver's license.
Yeah. Yes. I think that's what I've been trying to say. I know she has aliases. And I think she had a fake ID. I think she gave him a California driver's license. It's on the body.
But why do you think that?
Because I saw it on the body worn camera.
You saw on the body worn camera a fake ID?
I saw a California. He had his thumb over it the whole time, and it takes a long time to see it, but I was stuck with that thumb drive for so long. I looked at everything, and I'm telling you, and he writes it down on the police report, he doesn't even give a copy of her driver's license.
Okay.
And it says non-resident, it says Colorado.
Okay.
So that's discretionary and contradictory, unfactual information.
Okay. Anything you want to say in response to the driver's license issue?
Not at this time.
All right. So here's everything I'm going to take into consideration. So, Ms. Felvey has made a record. Well, let's go back in time a little bit. So the public defender entered on this case on the very first
I don't know. Could be jaywalking. I don't know.
court date, both when Ms. Felvey appeared for her setting a bond on February 14th, 2024, and for her first arraignment on April 4th, 2024. Thereafter, the public defender filed a entry of a conflict, and the court appointed Mr. Guard as counsel, who entered on June 3rd, 2024. Not long after that, Mr. Guard filed a motion of withdrawal. A hearing was held partially out of the earshot of the people on July 16th, 2024, and the motion to withdraw was granted, and new counsel was appointed. New counsel entered their appearance on August 28th, 2024, and appeared the next day, and a court trial was scheduled at that time. Hold on.
Okay. I got lost there.
It's okay. At that time, it was Whitney Stark who was counsel of record. The defendant entered a not guilty plea on August 29th, 2024.
Can I object to that?
No, ma'am.
Court guy, he just, it's
No,
okay.
please.
Sorry. I'm so sorry.
A not guilty plea entered on August 29th, 2024, speedy trial, thus expiring on March 1st.
That's the 6 months. I get it.
On
so.
March 1st, 2025. And at that time, the defendant waived a right to a jury trial, requested a court trial, and about...
That's her standby counsel. And thank God he knows where the mute button is. He's doing good. I think for standby counsel, he's doing better than... She's allowing him to do better than I've seen other people do.
10 days later or so, Ms. Stark filed a motion to withdraw, and the court held a hearing also partly outside the presence of the district attorney on September 23rd, 2024. And at that hearing, the motion to withdraw was granted, and the defendant decided to represent herself. And we went over an Arguello advisement, and she chose to represent herself, but I appointed Mr. Dawson Erdman as advisory counsel. Mr. Dawson Erdman was appointed advisory counsel and has been working with Ms. Felvey. It does not sound like in every way that Ms. Felvey wants Mr. Dawson Erdman to work with him, but he's working with Ms. Felvey.
I think this will kind of prove that.
Okay. And Mr. Dawson Erdman, I'm stating out loud, is not required to agree with you, have any sort of symbiotic relationship with you. He's simply helping you out, which I believe he's doing. And it's okay. And I also think it's okay for me to say it's okay that he doesn't agree with everything you do. Very few people agree with everything everybody does.
True.
So, and he's an attorney with experience and an eye towards litigation and strategy and what works and what doesn't work. So he's going to have that perspective. But he's not your lawyer, so you can still get a call the shots. You're representing yourself.
Okay.
Okay.
I don't think he wants to be attached to bad shots.
I've never seen Mr. Dawson Erdman turn down a fight. So if that's true, then and in my experience, that would mean he's willing to go to court even if it could lose.
Right.
Okay?
But
So
I don't
that's
think he's going to do that.
well. He's not your attorney. He's your advisory attorney. And let me continue.
Right.
Let me continue. So Mr. Dawson Erdman continued as advisory counsel, and when trial was scheduled, certain deadlines, motions hearing deadlines were scheduled. Those motions hearings deadlines came and passed, and then eventually about 8 days before the scheduled motions hearing date. Ms. Felvey filed a motion to recuse this court to recuse itself. And the court has already issued a deny the request for recusal. And I'm not going to go over the reasons for that. That's already been, record has already been made. So here we are on the date of the motions hearing, and on the date of the motions hearing, Ms. Felvey filed a motion today. And I think the district attorney is able to respond to some of that motion, but not all of that motion. And the portion of the motion that the district attorney is able to respond is that is not able to respond to is the request for dash cam video of 3 officers, the request for whether or not the defendant would get her right to a jury trial back with this new request. And they also object to the motion to continue with a speedy trial waiver. So, having heard from Ms. Felvey and heard that she doesn't have a lot of faith in the criminal process right now, and is frustrated with how things have proceeded up to now, the court will grant one continuance. And Ms. Felvey, I'm granting this continuance because even though I think I agree with Ms. Richardson, you should have been aware of the necessity of Alexandra Elliott being a witness, subpoenaing her to the trial scheduled on January 7th. I agree with the people that you should have done that.
I have confidence that you actually can, Snoopy.
Hold on. I'm ruling in your favor, so it'd be silly to interrupt me.
I'm going to interrupt you.
So you should have done that. You had these deadlines a long time ago, and you're not represented by counsel, and you had an advisory council who you could have talked to about these deadlines. You had access to all these legal resources, including the court's order of when witness endorsements were due. Hold on, ma'am. Please.
For real.
I'm ruling in your favor.
I get it.
Try not to deter me from doing so.
Okay, I'm sorry. I'm very sorry.
And you had resources to the case management order, the legal books, the internet, and all case procedure for this upcoming trial. And I agree with the people that you should have filed the endorsement of Alexandra Elliott. However, given the stress that you've described in preparing for this case, given the fact that you now wish to have a jury trial, and I'm going to give the people a chance to respond to that, and given that you have a witness that you believe is an important witness in your case, and recognizing that you're already frustrated with how long things have taken in this case, but you're willing to waive speedy trial to give everybody a little bit of breathing room and reset the trial, here's what we are going to do. I am going to accept your waiver of a right to a speedy trial. You understand by waiving your right to a speedy trial, Ms. Felvey, you're not giving up your right to fight the case or have a trial, but the DA now must bring you to trial by June 12th, 2025. That's the drop dead date, so to speak. You understand?
Yes.
Okay. And that's what you want to do. Just waive your right to a speedy trial? Yes?
Yes.
Okay. And is anybody threatening you to get you to do that?
No.
Okay. Then I'm going to find your waiver of a right to a speedy trial is knowing, voluntary, and intelligent. We're going to reschedule the trial, and we'll put it on the jury trial calendar. And then Ms. Richardson has 14 days to respond to the following. 1, request for dash cam. 2, request to really restore the right to a jury trial, which I am going to tip my hand, so to speak, Ms. Richardson. I'm inclined to restore Ms. Felvey's right to a jury trial, but I want you to take a look at it and see if you have any contrary authority that might be helpful. And 3, it sounds like the drivers, I think you've heard Ms. Felvey's request for the driver's license and her belief that there's an AKA or some sort of fraud. And I think you need to respond to that. So the last one is this. The Ms. Richardson filed a motion for a protective order for the victim's address in this case being provided to Ms. Felvey. Ms. Felvey, do you have any response to that?
No. I mean, yeah, I do. I've already been provided it. It's in its discovery. It's on the new driver's license with the new alias.
Okay, I understand that, but there's a new request that maybe you didn't even get it yet in the mail, requesting protective order prohibiting you from getting the victim's information from here forward. Do you have a response to that? What's that?
Is it dated?
It's just within the last couple of days, Your Honor.
It looks like it was e-filed
Snoopy wants to be dated.
on December 10th, so just a couple days ago.
Have they? No. See, I kind of need to be in the loop. So
I
now
understand.
it's our loop.
Yeah, I understand.
Okay.
I thought you were smarter than
Yes,
that.
I understand, and I understand there's a protection order already in the case, and I already have that information from her driver's license anyway, because it was sent from the district attorney.
Okay. So for future
I think
updates,
it's necessary.
understood.
Okay.
I'm going to grant the people's motion. I'm going to give the people 14 days to file that response, and I'm going to reset the trial. We'll set it in February or March, Madam Clerk.
So, Your Honor, if I could be heard quickly.
On the trial?
No, I just want to make clear that I provided Ms. Felvey a copy of that driver's license. And so now that would be in violation of the court order. Am I supposed to get it back from her, redact it? What?
Oh.
The court just granted a protection order that I'd be in violation of a court order if I do it in the future. And so.
Right. I can't undo the past. Wait, hold on, ma'am. Hold on. I can't undo the past.
Right.
So, Ms. Felvey, you can't have any contact directly or indirectly.
Yes.
Well, there's allegations that you haven't done this. So, you can't have any contact directly or indirectly with,
How can I ask you to expound on that? I haven't had any allegations.
according to the, Ms. Richardson, I'm going to ask you to re-engage.
Yep.
So according to the people, and I think it would be foolish for you to say anything, so I'm just telling you what this motion says. According to the people, the named victim believes that you have sent threatening messages to the victim. Because the people believe that, any change in her contact information is not going to be provided to you.
Okay.
That's it. Okay. Anything you wanted to add to that?
No, Your Honor.
Okay. So we're going to reschedule the trial to late February, early March, Madam Clerk. I know we're stacked, but
I am positive that this is going to trial. I am positive that she is not going to take a plea.
March 18th sound okay? March 18th and 19th.
Day after St. Patrick's Day? It's okay.
Yeah.
It's great. I'm a March baby, so I think it'll be good.
Okay. So, and then we'll do a pretrial readiness conference on March 14th at 8:15. All right. So jury trials reset, or the trials reset. It will possibly be a jury trial. I'll hear from the people and let them weigh in. To March 18th and March 19th, be prepared to be present on both those days. Pretrial readiness conference is on March 14th. You can appear remotely for that. DA has 14 days to respond to the request for dash cam video, the request for a jury trial being.
The chances of me remembering this on March 18th are 0.
Being the request for a jury trial being reinstated. And it sounds like from Mr. Dawson Erdman's statement
Jim, you have to come in stream on the 16th and remind me.
The driver's license issue is moot.
Yes.
Okay, so the driver's license issue is moot.
Oh, yeah.
So, you, Miss Felvey, will provide. Do you have Miss Richardson's email?
She does, Your Honor.
You need to provide by the close of business today, Miss Elliott's address. Okay. And then I'll look out for those 2 responses within 14 days. And then I'm granting the people's motion for protective order. I'm noting no 404B or expert testimony will be presented in this case. And Miss Felvey will have a trial, whether it's a jury trial or a court trial, and then you can put this whole thing behind you, whatever in the world the verdict is, okay? As far as Mr. Dawson Erdman, the only thing I'm going to say is...
You got to tell me because there's no other channel that gets this, Judge. None. 0.
Mr. Dawson Erdman is somebody who fights for his clients, but he doesn't fight for the people or the court. He fights for his clients. You're not his client. So as he advises you, recognize that he's not doing it for me or the people. He's doing it from the position of being a defense attorney. Okay. So you don't have to do, if he gives you any suggestions, you certainly don't have to take them, but he's not going to tell you to do something that's destructive to your case. And that's 1. 2, work with him even if you don't like him or get along with him. I'm not suggesting that you don't like him or get along with him, but work with him anyways, because it's better than not having advisory counsel. All right. We'll see you remotely.
Thank you for the 14 days in lieu of Rule 16 and the 21 days. I found out on my own about the motion deadline, and I had reached out to him a couple of times on email, and I didn't know what to do. So he said he filed it this morning, so I brought a copy and filed it.
Okay. We'll see you on March 14th. You'll email Miss Richardson by 5 with the address for Miss Elliott. And we'll have a trial, possibly a jury trial, and then you can put this whole thing behind you, okay?
Okay, great.
All right.
I think that's great. I just needed to get my foundation.
Okay.
Yeah,
Okay.
I appreciate it.
Yep. And that'll be the final continuance on the case. So.
Okay.
I need more foundation too, woman. Whew. Man. I don't even know what was going on today. Just nobody likes lawyers today. Lawyers are unloved today. If you see a lawyer, hug them because they had a bad day yesterday. Malkinson. Wackadoodle's good enough. Oh, yeah. Yeah. I will try. I absolutely will try. 100%. Hug a lawyer today. Go hug a lawyer. Don't hug this lawyer that you see on TV because I hear what happens when he hugs people. Hi, KS. All right, let's watch some Judge Fleischer. Let's get back to normal. Ready, guys? Here we go.
Page 17.
Oh, page 17, Jones. That was so good, page 17, Jones, that we don't even need to see anymore today. We're good. Victoria's so good at her job. Is that attitude already? Yes, sir. Twins.
Mr. Jones, you've now picked up a third case. You now stand charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 5th, 2024, officer initiated a traffic stop on defendant's vehicle for failure to display a front license plate while he was driving in the 5900 block of Mercer Street in Harris County, Texas. Officer made contact with the occupants and detected the odor of marijuana emitting from the driver's side window. All 3 occupants were detained for a PC search. The defendant provided the name of Kendrick Johnson with a date of birth of 8/30/2006, which returned with nothing. Officer used a mobile AFIS device and found defendant's real name to be Jamarcus Jones with the date of birth of 8/30/06.
I ordered you as
Bill. Mr. Bill. Your day shift, I'm night shift. No, I'm day shift, you're night shift. So you're the closer in this relationship. When you close, you have to leave everything set up for day shift. I'm tired of coming in and doing all of your side work every day. You're going to have to step up your game and start closing better so that us openers don't have to do all your side work. Okay? Hey guys, Bill is here. Bill is here. You just missed Allie. She went to bed.
a condition of your bond. And you promised me when you got here last time that you would not drive. Stop. Did you say that he was a driver here? Stop. Don't say anything. I don't want you. Don't. You have the right to remain silent. Exercise that right. I was under the impression, Rosette, that he's driving here. Is he not?
There were 3 occupants in the car, Judge. I'm trying to see if they clarified.
I love biscuiting so
He was a
much.
passenger. He was the front
I love
passenger,
that.
Judge.
Okay, so tell me, let's do a deeper dive.
Sorry?
Let's do a deeper dive. So they pull him over. He's the passenger.
There was an odor of marijuana detected.
So what happened next?
So they detained all 3 occupants for
Okay.
a probable cause search.
All right.
The driver was identified by his driver's license, and the front seat passenger, which is the defendant, provided the name of Kendrick Johnson. And a mobile AFIS revealed that that wasn't his true name. And so he was charged with failure to ID.
Do we have any co-defendants in this case?
Yes, John Burns.
Okay. So what's the cause number on that?
On that one?
Yeah.
It's
Huh?
25-417-01. That's in court 15.
Okay, is there a third co-defendant as well? Okay. Mr. Jones, I'm glad that you're not driving. Regardless, you've picked up a new case. I don't know what we're gonna do, but normally when you pick up a new case while you're on bond, we revoke the bond on the old case. So, I mean, it goes with you. I'm gonna appoint your lawyer today. We'll figure out how we go forward, but for now, I'm gonna take you in. I'm gonna appoint your lawyer. We'll see how we go forward, but you're supposed to behave yourself while you're on bond. You've now picked up a third case. You first have a felony theft, you got a second case, and now you've picked up a third case. Goes with you. Can you please one and one?
Next is page 29. Villegas. Come on.
So, hey, we're gonna monitor him now. No contact with any of the co-defendants. No alcohol, no dope. And I'm gonna appoint him a lawyer. I don't know what we're gonna do, whether we keep or not, but if for some reason we don't, I'm gonna send him for a test because I want to know what if anything. Did you say there was another one?
Villegas. That's
Was that the last one? Okay.
Judge, so
Jeffrey Villegas? Am I right? Okay.
Mr. Villegas, Your Honor.
Okay, so, all right, good morning, Mr. Villegas. So the reason that we're taking you in now is because you have a no bond warrant on an aggravated assault with a deadly weapon. I see that you're on bond for an aggravated assault from January. I guess there was a simultaneous also, I'm sorry. You an aggravated assault of a family member. You have a second aggravated assault. This one was a deadly weapon. And now with us, you picked up an unlawful restraint and an assault of a family member. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. All we're going to do is probable cause in these two. I'm going to keep you. It looks like you have a lawyer. Well, I don't want to do anything until we get your lawyer. Okay, so give me a second. Let me see. I have Mr. Villegas here. Are you going to be in today? You want me to just wait then to do probable cause? Sure. Okay. All right. Do you mind just putting back and we'll do it here momentarily? Thanks. Okay. I'm going to hold until, okay. Hi, good morning. How are you?
Hi, Anthony.
Thanks for being patient.
Mr. Sali, they're filing the dismissal on this case right now.
Okay, I'll sign it. Let me see if it's here. Okay, Julie. Yes, ma'am. Good morning.
Good. I put a motion to sub in the queue. It's on Caesar Jerome.
Is it on for today's topic? Okay.
He said on the 23rd.
I thought she was defendant.
Good morning. Ready?
Yes, sir. I'm here at Luis Pujol.
I thought he
Yes,
was a
sir.
defendant too.
We talked. He's a low BAC, but he did get.
This is a defendant. Cesar.
All right, so Mr. Vegas, we have your lawyer here. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Like I've already told you, you're charged with assault. You're also charged with unlawful restraint. Both of those you're facing up to a year in jail and or a $4,000 fine. Okay.
The complainant and the defendant are in a dating relationship. On December 5th, 2024, officers were dispatched to a family violence call. Officer met with the complainant who stated the defendant followed her down from their apartment to her vehicle and had stiff-armed her face. The complainant then left and went to a friend's apartment and the defendant.
Did you say he stiff-armed her face?
Yes, Judge.
Okay.
The complainant then left and went to a friend's apartment and the defendant followed. The defendant told the complainant to get into his car because he wouldn't talk to her. The complainant got into the passenger side seat and the defendant reversed aggressively and began driving south on North Main. The complainant stated she tried to exit the vehicle when the defendant stopped at an intersection, but the defendant grabbed her arm and prevented her from leaving. The defendant then began driving west on Rolling Brook Drive. The defendant stopped at another intersection and the complainant was able to exit the vehicle. She began running away from the vehicle and the defendant ran up behind her, grabbed her by the hair and slammed her face into the brick wall of the subway. The defendant then dragged the complainant by her hair to the truck, dragging her to the ground. The defendant tried to put the complainant in the truck, but the complainant was able to run away. Witness by an unknown vehicle tried to help, and the defendant was ID'd by his Texas driver's license.
Mr. Villegas, I'm going to find that there's probable cause to go forward on both of your cases. A protective order has been issued in this case on the 7th of this month. I would suggest you get to know it. If you violate the protective order, the state can and probably will file a violation of protective order against you. And I'm telling you, it's the capital murder of misdemeanors. It's one of the worst ones that you can pick up. The only thing that we're asking you to do is don't have contact with this person and don't be in possession of any weapons. That's all. As long as you can do that, everything here will be fine. Do you understand? This is going to survive for the length of the case. Don't have any contact. Don't use anyone else to try to have any contact with her. Social media, friends, family, anything like this. Do you understand? So Jed, it looks like the felony case is set for February. Do you want to, we usually do 30-day settings just so people don't get forgotten about.
Sure.
Are you okay with that?
Yeah, of course.
And then just keep us in the loop, whatever happens, and we'll just keep it, you know, in conjunction with however it goes.
Yes, sir.
Do you have any questions?
We'll talk.
If at some point you bond out, you have to come back here for bond conditions. Okay, I don't know if you're gonna bond out, but if you do at some point, you will need bond conditions because I want to ensure that you're not gonna have any contact with this person, okay? For now, we'll just put you back. Yeah, I mean, there's no need for you to say anything at this point. Just, I want you to understand that just, right. He'll take care of you, Mr. Vegas. We need him just to sign bond conditions saying that he's not gonna have any contact, not be in possession of any weapons, and then that's it. Okay?
Sure.
All right.
All right, thank you, Judge.
Fine.
I'll be right back.
Well, it's okay. No rush. I'm not. Trying to get this.
Okay. Okay, the one you were talking about. Yeah, I got you.
Thank you very much.
Yes, sir.
Yeah, whenever.
All right, the first one is page 27. Trevor Main, come on up.
Do you know if Nathan's coming here today?
Yes, he's on.
Up here, sir. Nathan has a case here today? Okay.
What's a fugitive, I guess?
What was it? What page? Got it. You were Mr. Trevor Maines? Shh. Mr. Trevor Maines, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. Oh, guys, crap. I'm sorry. Sorry, John D. And thanks, Mark. This is Mr. Trevor Maines. It's the last name, Trevor Maines. I guess under Trevor.
Sorry about that, Judge.
It's okay.
So officer, are you ready for me?
Yeah, okay. We're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers were dispatched to a bar in Harris County, Texas, in response to a suspicious person. The complaining witness, a security guard, told the officer that the defendant had left the bar and gotten into his car, but then returned a short time later carrying a gun. While there were other parties arguing in the outdoor area of the bar. The defendant took the gun and threw it under the fence. The complaining witness retrieved the gun, took the bullets out, and returned the gun to the defendant and told him to leave. Complaining witness then observed defendant go to the back of the bar and hop the fence to get back inside.
So they had told him to exit the bar, you said?
Yes, Judge.
Okay. Mr. Trevor, I'm gonna find that there's probable cause to go forward with your case. How old are you, sir? What do you do with yourself these days? What do you do with yourself these days?
So I'm unemployed, I don't have a job.
How come?
Just moved here. Moved out here.
From where? Okay, what are you planning on doing with yourself?
Job.
Okay, how long has it been since you've had a job?
Like 2-3 years ago.
2-3 years since you've had a job? How do you support it? How do you live? How do you eat? How do you get money?
I sell drugs.
Okay.
Trouble. See my record. I don't be in trouble.
So you have any prior criminal history?
Just carrying a handgun in a motor vehicle that was dismissed.
I'm ordering you as a condition of your bond not to go back to this place. Do you understand? Not to be in possession of any weapons. Do you understand? So how are you going to get a lawyer, sir?
Get paid for
So you're just going to do nothing and
You sign me a
so I don't want to talk to you, the case. I don't want to talk about the case, but let me ask you this. You haven't had a job for 2 to 3 years. Why should the people of Harris County have to foot a bill for you when you get to do nothing for 3 years? How is that fair that we all have to pay for your lawyer when you don't do anything? You get to play Xbox all day, just hang out at home and do nothing, and we have to foot the bill for that? How's that fair?
I don't have it, what we do.
So here's what we're gonna do. I'll have you fill out an application. I'm now making a condition of your bond. You've got to get a job. And I'm gonna bring you back in 2 weeks. I want to see what you've done to get a job. You're 27 years old, dude. This life is really, really tough without money. And the older you get, life doesn't get easier. It gets harder. You get bigger, you get fatter, you get uglier, you lose hair, right? And if you don't have a job, if you don't have a trade, if you don't have a way to make money, what do you think is going to happen? Do you think people are going to keep giving you handouts the rest of your life? That's how we have all these people who walk the street, looking all Quasimodo-like, have no way of getting money, no traits, no skill. That's not the way to go through life, man. Now is when you work your ass so that when you become 60, when you become 70, you have a cushion, you have somewhere to land. So you have a house, you have a nest egg savings. Because if not, I'm going to tell you now, you're going to have a really rotten and miserable life. This life is a journey, and it's really a good journey where you buy nice things, have nice clothes, take nice vacations, pretty wife, kids, or it can be a rotten toilet of an existence where you're in and out of jail. You ain't got no money. You're begging every single person for this and for that.
Bonjour. How are you?
And that's not the way to go through life. Did you even graduate from high school? I want you to get a job. I will give you a lawyer today, but you're not to use alcohol. You're not to use illegal drugs. And I'm going to test you like crazy. I want you to know that now. And I'm going to hold you to a standard as well. Do you understand? And if you don't, life's not going to go well between you and I. I'm just telling you that now. You will be held to a standard. I'm going to bring you back in 2 weeks. And I want to see what you have done to get a job. If you come back here and you ain't got nothing in your hand, it's not going to go well. Do you understand? You might give them an application.
Oh my God. Charlotte's here. Bonjour.
You heard the conditions, huh? No, right. Random testing, no alcohol, no dope, no going back to this location, no weapons. And JOB.
Job?
Okay. Vic,
Available on page 28.
good morning, Mr. Venable.
Yes, sir.
Mr. Venable, you're charged with 2 counts of assault. One is of a family member. On both of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, Ms.
On January 21st of 2024 in Harris County, Texas, officers were dispatched to an AFM call. Officer met with the complainant. The complainant and the defendant have been dating for 5 months. The complainant and the defendant were arguing. The defendant pushed the complainant to the ground, causing her to scrape her right arm. While the complainant was still on the floor, the defendant stepped on her neck. Officer noted.
Stepped on her neck.
Yes, Judge. Officer noted redness on the complainant's arm and neck.
You know if it impeded breathing?
No, Judge. I don't, I can't, let me check. It wasn't charged as an impeding breath, so.
Well, I know it wasn't charged, but is it?
The DIMS don't say that she had any trouble breathing, but I'll look at the offense report, Judge.
And here's the other thing. The first assault is from October of 23. The second assault is from January of this year. And now we have a felony evading arrest on December 10th.
Yes, Judge.
Were these two Bs? Was he out on bond for these? Vic, do you know?
It looks like. No,
So
just
this is
my
Venable,
boyfriend.
who's now picked up a third case. He had two misdemeanors, one's from 23, one's from 24. Did we ever do PC or had he ever been on bond
No, Judge. It was just a non-arrival.
for the whole time? All right.
Judge, it doesn't say that she had trouble breathing. It just says that it caused her pain.
Okay, can you do probable cause? So that's the family member, right?
That's the AFM.
Okay, can you do the first case? Because I don't think we've done probable cause on that one now.
This is the AFM from January 21st. Oh, the ABI, the one before.
Yeah, the one before.
On 9/29/2023, officers were dispatched. On arrival, officers spoke with the witness, complainant's wife, who said that the defendant assaulted the complainant by slapping him in the face because the complainant's dog killed the defendant's girlfriend's cat. Then officers spoke with the complainant, who said he had invited the defendant into his residence to discuss the situation when the defendant said she should knock the shit out of him. And the next thing complainant knew, the defendant had struck him across the left side of his face with his hand, causing pain.
Mr. Venable, I want you to understand one thing, that I'm going to do everything in my power to protect my community at all costs. And if that means I have to make your bond extremely high, taking you into custody, kicking and screaming, I'll do it in a heartbeat. Do you understand? I'm ordering you as a condition. I'm going to find probable cause on both of your cases, and I'm ordering you not to have any contact with either of the people in this case. There's a protective order that has been issued in the family case. I would get to know it. Don't say anything. You will get the opportunity. Now is not that time. I'm telling you what the expectation is while these cases are open, and what the expectation is for you to be able to live in this free world. Because if you don't abide by these expectations, I'm going to take the free world away from you. You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. You're also not to have contact with either of these people, not to be in possession of any weapons, and abide by the conditions of the protective order. If you violate those conditions of the protective order, the state can file a fourth case, a violation of a protective order. If they do, that is the capital murder of misdemeanors. It's one of the worst cases you can pick up, and you violate those conditions, I can have a hearing to hold you at zero bond, and I'll do it in a heartbeat to protect every person. Do you understand?
Yes, sir. Yes, Your Honor.
You should be ashamed to be late because there were some good ones today.
Do you have a Texas driver license?
I do, but it's
So you do not have a Texas driver license. I am now ordering you also as a condition of your bond not to drive. You will be signing an affidavit with me today promising you that you're not going to drive. I don't care what's going on in your life. I don't care what you got to do. I don't care where you got to go. You violate this, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car.
an Ubering to and from, so.
Don't. There's nothing you can say to justify. I'm not asking you. I'm telling you what the expectation is.
Yes, Your Honor.
We are now going to reset your case to give you time to hire a lawyer. So for now, I'm going to have you come up here, sign this order, promising us you're not going to drive. I will get you to Victoria where we will have you sign a reset for you to go get a lawyer. You will meet with Felicia for your bond conditions, and after that, you'll be free to go.
So.
The one in there that has contact.
Got it. Okay. So Rosette, the order in the one that's signed by the magistrate is allowing contact, but I'm gonna issue one now so that he can have contact. Okay, just so that you know.
Also, I don't see a motive on the assault bodily injury case.
Well, it's because it's not a family member case. That's why. You can only do one on the family member cases. All right, that way. John D. Hey, bud.
Judge, was that CHA? We let Victoria then. Okay, thank you.
John D.
Judge.
What's the word?
I'm gonna put first on young Mr. Cuellar, Diego Cuellar. He's due back today because he wanted some getting his GED. I spoke to him this morning. He had to get an ID in order for him to get his high
I
school.
think he's supposed to come here with his ID today, wasn't he?
That he showed me a proof that he's applying for it. He hasn't gotten the ID.
Come up.
And he's got proof on his phone that he's been researching the GED program. So he's taking active
Yes, sir.
steps towards the judge. He just doesn't have the ID in order for him to get the transcript. So that he
Where you haven't done
officially in the
absolutely.
GED program. right?
I have to wait for the school to mail me the transcript so I can get the ID. They said I need my old school record, so they have proof of who I am. But I have my GED login on my phone. I can show you.
To go get an ID, all you have to do is go to DPS and get an ID, right?
If they're under the age, they actually have to have a student verification form from a school.
That's what he's waiting for.
I was there
He's got
yesterday.
he's got.
What school is this?
Calhoun High School in Port Lavaca. Calhoun High School in Port Lavaca. I called them yesterday. They're gonna mail it.
The day before court, you call.
That was when I had my appointment
Zero.
for the DPS.
Zero.
Okay,
No possible
so how
way.
long are we
None.
gonna wait for you to
No.
get the ID to be able to start on your GED?
Well, they said they mailed it already, so probably it's like a couple of days, like 3 days.
So let's set it a week. Okay, all right, I'll see you in a week, sir. All right.
Okay, go ahead. I'll-
Judge,
I'll-
was
I'll
that
text you.
Cuellar?
Yeah.
Yes, that was Cuellar.
Okay, John D,
Did you
who's
get the
next?
results for his stress test?
Well, you sent.
Second, I'll check.
You sent him to get tested last time, but it hasn't been 30 days, Judge, because you wanted him to come back to show proof. So.
That's all right, John.
So I think by next time, he told me it's clearing out. So that's good. The next one I have, Judge, is, well, we have to approach on Mr. Imamovich, Judge. They're gonna
With an
file
I?
with an IMA.
Whether you're dismissing it?
Yes, there.
Yes, Judge. So I think, so we had dismissed the ABI, but I don't think we ever got the MOA dismissed. And so he got picked up on a VPO.
So.
But we don't plan on moving forward with the
Okay,
VPO.
all right, I'll sign it.
Got it, Judge.
Thank you,
And then
Judge.
lastly, I have Mr. Johnson, but they are.
So there's the proof. You see that?
Well, hey.
Even if the case gets dismissed, the DPO still lives on.
There you go, Judge. But it's good news, right things being
Yeah,
done.
you're doing it right.
Mr. Johnson, they are seeking some chief discussion in order to get that off your docket
The
today.
case
I'm
is
just
not
waiting. No, I got you, but I just want to give you an update on it. It might be off your docket today.
She's looking at that.
1 week. 1 week. No, make sure he's getting his ID, and then we're gonna start working on the GED.
To be clear, you wanted him drug tested on the second today for the results, and they're positive. Are we gonna retest anytime? So I can.
When was the first drug test?
The first one was on November 8th, and then the second one, we did it on December 2nd.
Both of those were positive.
Both of those are positive. I did check the levels, and it did dissipate quite a bit.
Okay, so where are we at now? You drug tested him today?
No, on the 2nd of December.
I know, but have we drug tested him lately? Let's send him right now
I think he went, he just went.
to do it.
Okay.
Great.
I'll create an appointment over there. Will you call him and tell him
I will definitely try to.
Okay.
Get it done.
Amy, Mr. Preston,
Who do you want to take?
are you not together?
We were just doing a waiver. We just need to get something signed.
Okay,
Hi, Judge. Judge, I'm approaching you on a case that's on your docket tomorrow.
Okay.
Can I give you the case number, Judge?
Or is it you want to do PC today?
No, I need a favor from you, Judge.
What's the cost number?
It's 2542069.
It's a DWI?
Yes, sir.
Okay.
Okay, here's the deal with this, Judge. This defendant has hired me to do his DWI and deportation case. He made bond here in your court and was transferred to immigration court. I'm putting together a bond packet to apply for a bond over there.
Okay.
The problem for me is if you revoke the bond here, then he's gonna like come back here, it's gonna turn into a mess. So I need to
I
reset.
don't care. I'm gonna revoke it.
What?
I'm gonna revoke it anyways. I'm kidding. I'm kidding.
Okay.
I'll let you, yeah, of course.
Okay.
Show me proof he's in ICE
I got it.
custody and then we'll set him off. Just, you need to keep me in the loop.
Yeah, I'll bring him here the very.
Yeah.
That he, and that's the hearing, actually, here's the result showing he's in ICE custody.
Send it my way. I'll code up for you, and then I'll send it back, and it'll be mwah. Judge got me there. The judge really, really got me there.
That's the
I
master
guess-
hearing, but I may get a bond hearing before then.
Okay.
So as soon as he gets out, I'll bring him here.
I trust you. Do you want to set it for the day after the 15th? You want to set it for the 15th then, for now? January?
Yeah, that's fine. I should hopefully have a bond hearing before that. I'll let you know, but like I said, if he gets out sooner, I'll bring him here.
Morgan, do you want to take notes? Did you hear that? Can I give you the cause number?
No, I have the cause number, Judge.
So he's in ICE custody. I'm not going to revoke it just because he's in ICE custody. He's got a bond hearing set
We don't
for,
have a bond hearing set yet. He's got a master hearing. And once I file a motion to set bond, they'll have a bond hearing. I haven't,
So what is it?
I have to get a lot of stuff. I need like tax returns.
so the master hearing is that a hearing to whether to deport him or not, or?
That starts that process, but if you get a bond hearing, if you get out on bond, what happens is your case gets transferred to a non-detained docket.
Okay.
So it will not, then that would cancel out that hearing. So I anticipate getting a hearing prior to that date. And hopefully he'll make, if he does, I'll bring him.
I've been sitting here for an hour and 37 minutes. I can stretch a little bit.
Then whatever day you want to pull.
Okay.
I don't care.
All right.
Just let Victoria know.
I'll let her
And
know.
we'll set it for that day.
Okay.
And once he gets out, if he gets out, next business day, he's got to come here. and
I'll
then
have him here.
You got,
I'll get him.
we're cool, okay.
Thank you. Thank you.
Okay. Yeah.
Judge, would you mind signing the Nolly for Mamovic? I'm just have an intake prosecutor asking me to send it to him for the PC, Judge. Thank you.
Yeah, I think I just gave
Don't
her
have
the
it.
case number, so she's working on it.
Okay.
I don't have it.
She's
Okay.
pulling it out.
Okay, sorry. You just sent me an email.
For who? I guess, right, I'm gonna withdraw the motion.
Right.
Because he's gonna keep getting arrested. Yeah,
Right, that's correct.
yeah.
And then the intake prosecutor is going to send your signed Nolly on the BPO to the magistrate there so that they'll find out. It's basically, it's just-
Who's really?
If you recall, you had emailed me about Tristan Johnson, and I was not going to be here tomorrow. He is here.
1 second.
It's on tomorrow's docket.
I'll probably get it. Oh, well, you want me like, if he gets out? Yeah, I will.
You mean that one guy?
Okay. So he is set for a BVR. Johnson? You need a cause number 2538599.
Tristan Johnson, come up.
This way.
I have not eaten a snail. I don't know if I can. I just don't know. You know how you watch Survivor and you're like, oh wait, I could do that. I could do that. I could do that. But then they get to that one challenge where you got to eat that stuff. That's where I can't go on Survivor. I mean, there's many reasons why I can't go on Survivor. But the eating of the bugs is the one that gets me the most.
I'm not happy with you, Mr. Johnson. You're on bond in this case, and now you've picked up a felony case. The only thing I asked you to do, behave yourself, don't pick up any new cases. And now, Morgan, what has Mr. Johnson picked up?
Unauthorized possession of a catalytic converter.
Wow, what happened? Please.
So officers were dispatched to an apartment complex. The security guard in the apartment complex observed the defendant.
Stop. Stop. There's really in charge unlawful possession of a catalytic converter.
Observed in plain view in the defendant's vehicle 3 catalytic converters that were freshly and jaggedly cut. The defendants were not mechanics. There's 2 defendants in this case. Defendant 1 was under a vehicle cutting the converter. When he saw security, he attempted to escape by jumping into a vehicle where defendant 2 was in the driver's seat. Security stopped them from leaving.
So where was Mr. Johnson?
I'm just trying to figure out if he was the number 1 or number 2 defendant, Judge.
Right, where was he? Was he in the car? How do we know if it's him? I don't want to try the case, right? But I don't want to.
Sorry, Judge, in the DIMS, they just identify the defendant 1 and 2. Let me just pull up the offense report really quickly. Okay, so Mr. Johnson was under the car. He was the defendant that was under the car, and then there was another defendant in a waiting vehicle.
Was he in the act of taking another one?
Yes, he was in the act of trying to steal a catalytic converter when the security guard caught him.
I am now going to revoke your bond on your first case. I asked you not to get in trouble. You've not picked up a felony case. Is there anything that you would like to add?
Your Honor, I would ask that the court set a bond and obviously.
I understand.
Yeah.
That's, each one of those is like $5,000-6,000 and someone has to. Life's hard enough as it is, man. You know, really. It goes with you. Okay. 5,001 or 5,002. No, yeah.
5,002?
Yes, yeah. Okay. Correct. Okay, thank you. Sorry. Okay, you ready? Hey. Yeah. Hey, man.
I have Aaron Reyes. Hey, Doc. He picked up, I think, picked up 1 felony for sure upstairs.
Is he in there?
And look, Judge.
Reyes?
Yeah.
Let me see. Hold on.
And it's page 41, Your Honor.
Thanks. I'm trying to look at. Yeah, okay, so that's right. Eddie, he's on bond for UUMB. We got him on, picks up a gun case and he picks up a delivery case at the same time. Now he's picked up a possession of an unlawful use of a criminal instrument. I mean, I can't, he's on bond. I'll leave it at, I'll do it at 5,001,
I understand.
but
They're trying to no bond him, so we have a bond hearing upstairs, January the 23rd.
okay, just keep us in the loop. and
Yes,
then
sir.
It's at 5,000 now. I'll revoke it, set it at 5,001, and then you just keep us in the loop.
Thank you, Judge.
Okay, thanks, man. That was Reyes, yeah. I think he was on a,
Thank
I want
you,
to say.
Maiko.
Was he on a PRO mode?
Thank you, Maiko. That's awesome.
No, it was a shirt.
Hi, Anna.
Judge, write-in.
Let me put it to where there's. So are you okay with going without an agreed rec, Ms. Siegler?
Sorry?
Are you okay with going without an agreed rec? Where was the weapon initially? Do you know?
It was found on the bed.
Just a gun is laying, a gun is, just- well, I mean, do we know where it was initially before it was used? I guess that's my question.
There were several guns in the house. If you, one moment, let me pull up the OR, but this one that was involved in the accident was found on the bed. 1 second. The mother, the complainant, or sorry, next of kin advised that she
It's okay. I'm reading without glasses.
was told that one of her children was trying to make the bed and in the process moved the firearm and it was discharged. And the child did not know that the gun was loaded.
The worst, that's the worst nightmare.
I know.
It's just, it's awful. I don't know. I don't. I think that there has to be some punishment, right?
Your Honor, we're happy to speak to him and have him redo his mitigation packet.
But the thing is that he's had the chance to do it. You know what you're supposed to do. And if you can't own up to it at that time, then, I mean, that's truly what you mean at that time. Right? So,
She's still upstairs in my bed.
I'd like to see it, if you don't mind, his letter to see how he feels. Is he truly remorseful? Because, on one end, I would think that the fact that your own child is dead because of you, is that punishment enough? Right?
That's where I was at too, Your Honor, which I was conflicting on.
If you can't even take responsibility for it, I mean.
And the next,
I need these bees.
Just initial it. Where is it?
Give me the letter back. I want to get scanned.
Oh, this one, the
Just
withdrawn?
initial it or where it says withdraw?
Remind me, I got to sponsor the tent again this year. I didn't do it last year because my wife was pregnant.
I'll get you some. I haven't got my form yet, but when I get, I'll just.
Did he say? Did he say I didn't do it last week because my wife was pregnant? What? She's not pregnant this week. Did it just pass? Oh, don't worry, it'll pass in an hour.
Okay, Dustin.
Good morning, Judge.
I don't get
So, yeah, Ben heard from me last week. I was in Kingpin. I guess there's a TBR for positive alcohol.
He's out now. Don't want any more issues. Just. I don't want any more issues. I'm not asking much. Just do what you need to do. Really, you know?
The pretrial, I talked to pretrial, they said they're gonna, they listed it. About the THC rating. I don't know what you wanted.
God, it's only 70 days old too. All this trauma and it's only been 70 days.
Is that it? The lab is back. There's no alcohol, which we expected that already. We're still waiting for drug analysis, but I think as soon as that's back and the state's ready, we just either just try it or, just try it. Let's get done.
Is that where this is headed?
Well,
Nothing.
I looked at I've evaled it, and I don't think it's the DWI. I don't think it's intoxicated when I looked at the eval, but but the state can't do a full eval until they have their labs for the blood. And
Tell me what you
I
think.
expect that.
I'm going to tell you now, this has so much drama, Ms. Saba, that I'm like ready to pony it up with Dustin as well. You know, I don't want to sit and wait another 6 months. And,
Judge, we don't,
oh, that's wonderful. Hi, you look great. You know,
what were you?
It's gonna be an alleged drug case.
Oh, yeah. We don't,
Is there
we
a
just don't
DRE
have the
done?
toxicology
Judge?
report
DRE?
yet, Judge.
I can't hear, I'm sorry.
DRE, shh. Was there a DRE?
DRE? Yeah.
We just don't have the toxicology report yet, Judge, so, and the case is only 2 months old.
I know. No, well, yeah, a little.
Lori, Nan, you know what surgery she went through, right? Lysergity, right? How much time is she gonna be asleep? Like, I feel like maybe she could text already.
A bit over, but yeah.
A little bit over.
How long do you think it'll take?
I think it would take 1 more month, because sometimes I've seen them take up to 4, but maybe we can give it like 1 more setting before we.
Yeah. Okay, we'll sit you off 30 days.
Still,
I agree with that.
To do drug testing.
Yeah, just don't use, you know? All right, so we'll continue supervision now, Felicia.
Bad John. They're called geniuses. Please, show some respect.
Just to clarify, so you are permitting the usage of THC?
No, I don't,
So that's like the dilemma here.
I know.
So I don't, because we're just gonna continue about.
Yeah, I mean, how do we deal with this? I don't,
I mean, there's very, very low chances of complications with something like that. Right? I mean, they don't cut the throat, they go down into the throat, right? I don't know.
Let's get the labs back and
Yes,
eval it and try it.
I'm not down with you continue to use marijuana. I'm not down with it, Mr. Jones. I don't want you to use. There has to be an alternate method to dealing with issues.
See a doctor and all kinds of stuff still though.
Yes, yes, that's what you're supposed to do. You're not supposed to self-medicate.
He's not self-medicating. He's got a prescription for marijuana, and I know we've gone down this road already. So he's not self-medicating. He's under a doctor's orders.
That's not what
He
it
has
was.
a second DWI that's open. I don't want you using, Mr. Jones.
That's what it
Just
was.
the plain and simple of it. I mean, don't. Do you understand?
I mean, fine, she's in pain, but we're in pain. What about my
Don't
pain? Where's Kelly?
Use and get ready, please. It's way too much drama. I'm ready to put this baby to bed one way or
That's
the
not
other.
helpful,
Reach out to
Rose.
the lab and do an
Please.
eval.
All right, I'm going to do 30 days. I'm going to continue it now. Don't use. You've got 40 days. Do you understand? Yes or no?
Sir.
Okay, get ready. All right, Dustin.
I just hate remembering the exact same suit and tie.
I'm happy that you're here. I hope you had a great vacation. You know,
I did a no work, like 0 work vacation. I didn't take my laptop.
that's what it's supposed to do. We love you, Dustin. All right. Hi.
Guess
You figure it out?
what time it is? Bren's here, so we gotta go. Hi, Bren, you're late. Elisa, you're late too. Guys, I am going to start another live in 1 minute with sound. for the OJ trial. And we're going to do it without Kelly, unless she pops in any minute now to say that she's awake and everything went well. So grab your popcorn, get ready. We're still in the preliminary hearing, so yeah, I mean, if you don't like the OJ trial, you don't have to attend, but it'll be fun to talk to everybody. Thanks, Monica. Yeah, she's going to be okay. You know her. You know her, Kelly. All right, guys. See you in 1 minute. Bye, guys. Thank you so much for coming out. I really, really appreciate it. Wrong one.
Electric light, late night when the world sleeps. She's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Right, even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue, in her jokes there's a truth so true. With each string she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no